Honourable Senators, during the committee hearings, witnesses from the bar argued strenuously that the law would infringe the Charter. On the other hand, the committee heard testimony from the minister and government officials and received briefs from prominent law professors Peter Hogg, Robert Solomon, and Dean Ericus Chamberlain, all of whom supported the constitutionality of mandatory alcohol screening under the Charter. And on the last day of its hearings, the committee also heard from a leading criminal law scholar, Professor Don Stewart, who also argued against the constitutionality of the bill on grounds that it violated Section 8 and would not likely be saved under Section 1. He went on to state in a line that I suspect we will hear repeated on more than one occasion during this debate, that, and I quote, "The Supreme Court of Canada has never saved Section 8 violation under Section 1, close quote. Now, j'ai beaucoup de respect pour le professeur Stewart, et à moi, je crois qu'il...
I have a lot of respect for Professor Stewart. Nevertheless, I think that he is wrong and that Professors Hogg, Solomon and Chamberlain are right to believe that mandatory alcohol screening will be deemed constitutional. But I'm not here, honourable colleagues, to insist on this. It is rare that constitutional law be so clear. The truth is that there are solid arguments on both sides and that the rights and constitutional values are at stake here. These are thorny issues, and thoughtful, intelligent persons may very well be in disagreement, but that is precisely for this reason that I believe that it is inappropriate on the part of the committee to remove mandatory alcohol screening from the legislation.
Colleagues, as I stated in my speech on second reading, I'm sorry, I jumped too far ahead. Now, it would take me too much time and take us too far afield to fully develop the constitutional analysis in support of my view that the bill would withstand constitutional challenge. So, with regrets, you're going to have to do without extensive quotes from the witnesses and extensive quotes from the Supreme Court of Canada jurisprudence. I apologize. So let me simply make the following points, and I'll be happy to take any questions you may have. First, there's a strong case that mandatory alcohol screening would not, in fact, infringe Section 8 of the Charter. The law would be prescribed by law, the law is reasonable, and the demand for the breast sample would be obtained in a reasonable manner. Professor Hogg makes this case very succinctly and persuasively. But in any event, mandatory alcohol screening would likely be upheld as a reasonable limit under Section 1. Building upon the jurisprudence in the courts, upholding random stops as reasonable limits to the right not to be arbitrarily detained and the right to counsel. Now, as I stated in my speech on second reading, Bill C-46 would clearly satisfy the first two parts of the four-part test that the Supreme Court has established under Section 1. First, the Court has ruled that reducing the harm caused by impaired driving is a sufficiently important objective to justify limiting Charter rights. And second, whatever else you may think about mandatory alcohol screening, it clearly bears a rational connection to the bill's objective of deterring drinking and driving. Now, the third and fourth part of the test speak to proportionality. Does the law infringe the right no more than is necessary to achieve its objective? And do the benefits of the law outweigh the infringement of the right? Le comité a entendu
The committee has heard testimony according to which up to half of intoxicated drivers evade policing under the current system.
D'après d'autres témoins,
According to other witnesses, those countries that have implemented mandatory alcohol screening have seen a significant reduction in the number of incidents of impaired driving and accidents involving this kind of driving. However, opponents to this legislation call into question any value that should be put in these studies and have confirmed the expected outcome is only hypothetical. Others, such as Professor Stewart, believe that this is completely irrelevant because those countries, a number of the countries that are cited, do not have a Charter of Rights and Freedoms that's part of their constitution. Based on my reading of this testimony, opponents are wrong.
Records amongst comparable developed countries and lags behind the over 100 countries who have already introduced mandatory alcohol screening programs of some kind. And although the experience varies from country to country, the evidence seems compelling that mandatory alcohol screening is more effective in reducing and deterring drunk driving than the alternatives. Now, the critics of mandatory alcohol screening disagree, and they point to the differences between our regime and others. However, several jurisdictions had regimes similar to ours before they introduced mandatory alcohol screening, and in my reading of the relevant literature, I'm satisfied that the studies demonstrating the effectiveness of mandatory screening, properly controlled for the relevant factors, including the state of the law before mandatory alcohol screening was introduced, the impact of public education campaigns, and changes to the levels of police and enforcement. And in my opinion, therefore, the government had a strong evidentiary basis upon which to conclude that the introduction of mandatory alcohol screening would materially reduce the number of drunk drivers who escape detection and thereby reduce the harm caused by drunk driving. And finally, mandatory alcohol screening restricts charter rights no more than is necessary to achieve the important objectives of the law. Now, colleagues, we must keep in mind that police already have the power to randomly stop drivers under our current law, both in common law and statute, and they can do so to verify licensing, ownership, and insurance, and importantly, sobriety. The power has been repeatedly held to be constitutional over many, many, many decades. Bill C-46, rightly or wrongly, doesn't change that. The only change that it introduces is to remove the requirement that the police have a reasonable suspicion that the driver consumed alcohol before the police can demand a breath sample. And nothing else changes with respect to the subsequent steps that drivers must do if they fail that roadside test. So if you believe that mandatory alcohol screening would reduce the number of drivers who escape detection, and remember, the evidence suggests that it is as many as 50%, then the answer is clear. And moreover, our courts have recognized that we have different expectations of privacy depending on our circumstances. Driving is already a heavily regulated activity, and our reasonable expectations of privacy, which is at the heart of the Charter protection, they're different when we get behind the wheel as compared to when we return to the safe confines of our homes. And indeed, as you know, we are subject to be searched, frisked, and even x-rayed and our skin swabbed when we go to an airport to board a plane. Now, of course, the taking of a breath sample engages us in a more personal and intimate way than simply a demand to produce proof of insurance. Our breath is the very essence of our life. Nevertheless, a demand for a breath sample is far less intrusive than a body search or a demand for a blood sample. It reveals no personal information about the individual except their blood alcohol level. It's transitory. It takes very little time to administer. Mandatory alcohol screening ensures a brief encounter. The officer is required to have an approved device in possession, and the driver must be in care or control before the demand can be made. And because it is mandatory, it causes no stigma or embarrassment to drivers, and the results are not retained in evidence. So on balance, I believe that there is ample evidence to support the view that the introduction of mandatory alcohol screening in Canada would be more effective in reducing the incidence of drunk driving than the maintenance of our current system, and that it would infringe our charter rights no more than is necessary to achieve that objective. And so I conclude that the introduction of mandatory alcohol screening is constitutionally valid. However, I'm very mindful that there are strong arguments to the contrary. We heard them at committee, and you'll hear them again in the chamber. And if my amendment is successful and mandatory alcohol screening is returned to the bill, it'll be challenged in the courts, of course. And we don't know how the lower courts will rule before the cases find their way to the Supreme Court. There's no way to avoid this short of accepting the status quo and never legislating in this area. And when it gets to the Supreme Court, it is virtually impossible to predict how the court will rule. Only either the most inexperienced or the most arrogant student of the court would claim otherwise. The fact is, the Supreme Court has changed its position on critically important charter issues over the years. The law in some very important areas remains unsettled to this day. It doesn't consider itself bound by previous decisions unless it decides it wants to. And more importantly, for our purposes, the court's approach to how it applies Section 1 has varied dramatically over the years, depending on the issues before the court and the changing composition of the court. So, what do? What is our constitutional obligation as senators when we're faced with competing and conflicting arguments from reputable lawyers and reputable academics who disagree on the constitutionality of this bill? And I come to the heart of why I'm taking, je prends la parole.
Of why I rise on this matter.
As parliamentarians, just as it binds government and the courts. But we all play different roles in interpreting and applying the Constitution, and it's critical that we as senators recognize and respect the distinctions that obtain between the Senate, the House of Commons, the government, and the judiciary. And we can put them all together, the difference between Parliament and the government, Parliament and the judiciary, and so on. Now, as senators, we have a responsibility to ensure that proposed legislation respects the Constitution and its values. And in this respect, we have a duty to interpret the Constitution as best as we can. But we're not a court of law, much less the Supreme Court of Canada. Yes, there may be circumstances and some situations, we can all imagine them, where the infringements of the Charter are so blatant and the arguments for upholding the laws so flimsy and so spurious that it would be our constitutional duty to refuse to pass such a law. But that is clearly not the case here. We have arguments from reputable academics, including the one who is cited more often in the Supreme Court of Canada than any other author in history. We have the leading experts in impaired driving law. And yes, we have reputable defense lawyers and civil liberties lawyers from the bar. So I come to this, Senator, where the government's policies are reasonable, where they're based upon credible scientific evidence, and where its constitutional position is supported by impartial and distinguished academic analysis, we ought to accept the policy decisions that were approved by the elected House of Commons. Yes, our responsibility is to ensure that the laws respect our Constitution and its values. But unless a bill so obviously and unambiguously violates the Constitution, and that is clearly not the case here, the Senate should not substitute itself for the courts. To do otherwise would be to go beyond our legitimate role as an independent and complementary legislative body and assume a constitutional role for the Senate that properly belongs to the judiciary. So it is for these reasons, honorable senators, that I hope that you will support this amendment to reintroduce mandatory alcohol screening into Bill C-46. The safety of all Canadians is in our hands. Thank you.
Senator Gold, I know there are a couple of senators who wish to ask questions, but your time has expired. Are you asking for 5 minutes?
I'd like time to answer questions. Thank you.
Leave granted, honourable senators? Is leave granted, honourable senators? Senator Carignan, was that a no or a...
That was a yes.
Yes. Senator Jaffer.
Lost in the translation.
Senator Gold, thank you very much for the work you've done on this issue and also for your speech tonight. You know, Senator, there is the constitutional argument, there is the argument of us legislators working on this issue, but there is an implementation issue that we have to also address. And you know, I come from a community, and there is 20% now of Canadians who gets mandatorily stopped driving while black. Whether it's constitutional, whether it's legislative, on the ground, because it's mandatory, MLAs in Toronto, prominent people in Toronto get stopped. My question to you is, what do you say to those people that will be stopped for this mandatory because they are black?
Senator Gold.
Thank you, Senator, for the question. You know, I don't have a great answer. I mean, I'm going to try to answer your question. This is a real problem. All of us know it. We know it either from our own experience or in our own communities. I know it in the province of Quebec, especially with regard to Indigenous people in certain communities. In the year and a half I spent on the parole board, I had cases all the time of people being profiled. And I deplore, if I might say, the lack of baseline data. I mean, we have very little data. We know it's a fact. And I deplore the lack of baseline data to properly understand it. And I wish the RCMP and other police services were more open to gathering it and helping us understand better. So let me make two main points. First, to distinguish between random stopping versus mandatory testing. Again, and you know this, random stops are a fact of law now. And they can stop you for sobriety. This doesn't change that. And the profiling that you described and that goes on around the country remains a problem and will continue to remain a problem. So I have no answer in some sense on that point. The second point I want to make is to distinguish between, and this is maybe distinguish between stationary checkpoints and ad hoc random stops, okay? So if we're dealing with a stationary ride program here in Ontario, the stationary stop, there's really two situations. If you set up a stationary block only in neighborhoods that are in which live racialized and other vulnerable minorities, and you don't send them up anywhere else, then you may not be profiling everybody, because a stationary one, everybody gets stopped, but you're only picking on one vulnerable group. That's a problem. That program itself, in my opinion, would be an unconstitutional application of an otherwise valid law, and would and should be challenged. If you set up the same stationary road ride program, or whatever it's called in other provinces, I don't know, in Yonge and Eglinton, I'm picking, I don't know, I used to live in Toronto, in a diverse neighborhood, and everybody gets stopped, and in fact, mandatory alcohol screening reduces racial profiling because there's no discretion, and everybody, regardless of religion, color, or look, gets stopped. So that's one situation. Again, the other is, but you can't do this everywhere, all the time, in every community. It doesn't work, and it's not effective, even in cities and much less in rural areas. So if we're dealing with random stops, again, the problem doesn't go away, but it's not aggravated, in my judgment, by this. But remember, you cannot, you have to have it has to be a legal stop. A stop that's motivated by racial profiling is not a legal stop. Now, it's cold comfort, of course, if you're stopped and if you're required to blow and if you fail the test, because then you'll get, into the system. It's a part of an answer to say, well, you could challenge it in court as being an improper, illegal stop, the way you can now challenge it by saying there was really no reasonable suspicion I had alcohol, it was biased. But again, it's cold comfort. So do I have a good answer? No. It's that mandatory alcohol screening, though, doesn't create the problem. It may solve it in some cases, otherwise it leaves it rather unaddressed. But I would say this to conclude. As I said before, this is an issue that preoccupied us in committee. It preoccupies all of us who care about the fair administration of our laws, not just the contents of the laws.
Senator Gold, but your time has expired. Is leave granted, honourable senators? I hear a no, Senator Gold. I'm sorry, but your time has expired. Senator Pratt. It's moved by the Honourable Senator Pratt, seconded by the Honourable Senator Sinclair, that further debate be adjourned until the next sitting of the Senate. It's your pleasure, Honourable Senators, to adopt the motion. Adopt, take care.